Good morning, everyone. Welcome and thank you for joining us for the third session in our ongoing webinar series on trade regulations. My name is Ann Meredith, and I'm thrilled to be your moderator for this webinar hosted by UPS Supply Chain Solutions. As you know, as global trade continues to shift and evolve, staying informed is not just important, it's essential. In today's session, we'll dive into the latest developments in trade policy, tariff updates, compliance strategies that could have a direct impact on your business operations. Our goal is to equip you with the insights and tools needed to navigate regulatory changes confidently and proactively. Before we begin, I have a few admin updates to share. This webinar is being recorded and it will be made available to everyone who registered. We encourage your participation, and I'm excited to share that we have several of our compliance subject matter experts on. So if you have any questions at any point, please use the Q&A function at the bottom of your screen. We will try our best to answer your questions live on the call through the Q&A function, or if necessary, we will contact you privately after the call. And lastly, at the end of the webinar, a short pop-up survey will appear. We'd really appreciate it if you could take a moment to share your feedback. It helps us improve future sessions and tailor the content more to your needs. And now for legal purposes, I will read the following statement verbatim. At the date of this publication, policies are evolving. This presentation is for informational purposes only. It does not constitute legal advice. Please consult with your own legal counsel for such advice. Do not rely on this information without performing your own research. All right, with that, let's start by introducing our distinguished speakers who bring a wealth of experience and insights to today's discussion. First, we have Mark Hartledge, Brokerage Compliance Manager, Catherine Miller, Vice President, Global Public Affairs, and Jessica Rosen, Senior Director of UPS Trade Advisory Services. Welcome to the speakers, and thank you for being here today. And now we turn over to the agenda. You see we're going to start the conversation with trade and tariff updates and understanding the August landscape. Then we'll dive into the compliance and regulatory outlooks, and finally, strategic responses to all of these changes. And so with that, I will turn it over to Mark to get us started and walk us through the key changes and what they mean for your operations.
Hey, Ann, thanks. And hello, everyone. My name is Mark Hartledge, as Ann stated, and I am a U.S. Brokerage Compliance Manager on our small pack division. Today, I'm going to take some time to discuss the current trade landscape for U.S. imports. For those of you that may have attended previous webinars, you may have seen you'll see some familiar info with some additional details. And for those of you that have not, I hope you find this information helpful when it comes to importing to the United States. All these regulatory changes have not only impacted the way we conduct brokerage business, but has had a big impact to our customers. And we understand that. If you import anything into the U.S., you have likely been impacted. These changes have come fast and furious and can be very difficult to understand. So in the next several slides, I will review a timeline for June to September and the regulatory updates that we have seen the largest impact come from. We will then provide some insight on several of these old and new trade remedies and how to understand them better. So now I want to review an abbreviated timeline for several key events. As you see from this timeline, there's been several regulatory changes and updates made over the last 4 months. I'm not going to cover every event on the next 2 slides, but we'll focus on a few that have most likely impacted our customers. We'll start out on June 28th. That's when U.S. Customs provided additional guidance regarding Section 232 tariffs for aluminum derivatives. We now have to report the country of cast and smelt, and if it's unknown, those products may be subject to 200% tariff on it. We will review this in a future slide, as this can have a large impact to your imports. Next, on June 30th, the U.S. and U.K. economic prosperity deal was announced. This provided for lower tariffs for U.K. products that included auto and auto parts. Then on July 6th, U.S. Customs and the U.S. FDA updated guidance regarding shipments containing FDA-regulated items. The impact of this change has been significant, so we will dive into that a little deeper later in the presentation. Moving forward to July 9th, U.S. Customs extended the current IEEPA reciprocal tariffs to to August 1st, which was later moved to August 7th. This was put in place, or this was delayed for more time to have more trade agreements and negotiations. On July 22nd, the US, Japan, and Indonesia announced the framework of another trade deal that would adjust the reciprocal tariffs to 15% for Japan and the Indonesia reciprocal tariffs to 19%. The US would later make further modifications to both trade agreements. We will talk more about the Japan trade deal later in the presentation. Next came the announcement of the US-EU trade deal that was announced on July 27th. This is another topic we'll provide more details in a later slide. July 30th brought more changes and announcements. First, U.S. Customs announced there will be an additional IEEPA tariff of 40% for products of Brazil. They also announced a new Section 232 tariff on copper and copper derivatives. And on that same day, it was announced that the de minimis exclusion would be suspended for all countries. All three of these announcements will bring major changes, so these are additional topics for further review in the upcoming slides. We then saw on July 31st the announcement that the Canada IEEPA 1 tariffs would increase to 35% for those non-USMCA products. This substantial increase is all the more reason to assure you utilize USMCA for your Canadian products. Moving on to the next page and into August, and specifically August 7th, U.S. Customs implemented the updated IEEPA reciprocal tariffs at a country level rate. On August 12th, U.S. Customs proceeded with the planned enforcement of the $800 per day per importer de minimis shipments. At that time, U.S. Customs began rejecting shipments where the same importer was importing more than $800 per day of product under that de minimis exclusions. This would stay in place until the full suspension later in the month. Then on August 18th, U.S. Customs then added an additional 407 tariffs to both aluminum and steel 232 tariffs. This was a large change for that tariff. August 27th brought the additional IEEPA tariffs of 25% for all India imports. The U.S. stated the additional 25% would be on top of the normal IEEPA 2 reciprocal tariffs for that. Then comes August 29th, which brought the implementation of one of the largest changes to the importing community that we've ever seen. U.S. Customs suspended all de minimis exclusions for all countries. We will talk about this more in detail later in the webinar, as it is a huge topic that's current. This brings us to September 9th, where the Supreme Court announced they will hear 2 cases on an expedited basis regarding the legality of all these IEEPA tariffs and IEEPA regulations. Catherine will dive into this later in the webinar also. So in the next 3 slides, I'd like to touch on the Section 232 tariffs for automobiles, auto parts, the 232 copper and copper derivatives, and the 232 tariffs for steel and aluminum. These are not all new, but as we've navigated through these regulatory changes, we've seen these 3 trade remedies become very challenging. So I wanted to review these again and provide updates that we have seen from U.S. Customs. First is the Section 232 tariffs for automobiles and auto parts. These tariffs are all driven by certain tariff numbers that U.S. Customs has deemed have an impact on an industry's trade deficit. Starting on April 3rd, a 25% tariff was imposed on all passenger vehicles. This was applied to all countries that import in the United States. 1 month later, Section 232 tariffs of 25% were implemented on the auto parts for those passenger vehicles. So over 130 auto part tariff numbers are now subject, or were then subject to 232 at a 25% rate. This trade remedy of auto parts takes precedence over the other Section 232 trade remedies that I'm now going to discuss. Since the implementation of these 232 auto tariffs, we have seen several trade deals that have reduced these tariffs. All countries in the EU, along with Japan and South Korea, now recognize a 15% tariff for these auto tariffs. Moving on to the next slide, The newest Section 232 tariff that has been added from customs is for copper and copper derivatives. Derivatives being those products that contain copper and not wholly made of copper. These items can also be outside the normal copper chapter in the tariff book. So on August 1st, U.S. Customs started charging these Section 232 tariffs for copper and those derivatives at the 25%. This tariff does apply to all countries as being charged at a 50% rate. For the derivatives, you only have to pay the 50% tariff on the value of the copper content. So it's to your advantage that you understand your product and the breakdown of your product. If you do not know the value of the breakdown, you may have to pay the 50% on the entire value of the product. The next item we'll review will be the remedy for steel and aluminum and the derivatives thereof. This trade remedy has become a very challenging one as there are several different requirements for both products and derivatives. As an example, once an item is identified as an aluminum derivative, you must now know the country of origin of that derivative and the country of cast and smelt for that aluminum derivative. For aluminum, if you do not know the country of cast or smelt, you can be charged up to 200% duties for those products. This means you need to know the value breakdown of the aluminum portion and the value breakout of the non-aluminum portion to avoid paying 200% on the complete value. We understand this can be very difficult to obtain, but it is a requirement of U.S. Customs. If you do not know the country cast or smelt and you do not know the value of the content of the aluminum portion, then you're paying 200% on the full value of the product. That's huge and can have a big impact to your imports. So documentation and a strong understanding of your products and how they are produced has become even more important now with these remedies on trade on steel and aluminum. You should work with your suppliers, your vendors, and your manufacturers to assure the details are provided. Without this information, it can be very costly when importing these steel and aluminum items. On August 18th, U.S. Customs added an additional 407 tariffs to both steel and aluminum, thus making it even more impactful. Next is a topic that we spoke about in our last webinar, but just like the Section 232 tariffs, it can be very confusing, and that is stacking of these tariffs. So I want to review the stacking guidelines for applying all these different tariffs. There are several products that may fall under multiple 232 tariffs, and in most cases, you're only responsible for paying tariffs for one of those Section 232 trade remedies. U.S. Customs has recognized this as a very complex process, so they have issued guidance on this topic. On this slide, we provide the details from U.S. Customs on how we stack tariffs. As I stated earlier, the Section 232 auto and auto parts trade remedy takes precedence over all of them. If you have an item that is subject to 232 auto, then that item is not subject to 232 copper or 232 aluminum. It's also not subject to the IEEPA 2 reciprocal tariffs. So you're only going to pay the Section 232 tariffs one time and not have to pay the other ones if it applies for that product. However, if the product is of China or Hong Kong origin, subject to the IEEPA 1 tariffs that were initiated back on February 4th. Moving forward, here we go. Moving forward, we look at the 232 coppers tariffs. If you have 232 copper tariffs, then you will not pay anything on the steel 232s or the IEEPA 2 reciprocal tariffs. And then lastly, I will say, if your item is subject to China 301 tariffs that were implemented back in 2018, those tariffs are not impacted and you will still be subject to those. So as you can see, the stacking process can be very complex. All right, moving forward to the next slide. And that next topic is something that is not new, is not new either, but is a topic of great deal of relevance over the last 6 to 7 months. I'm speaking of the country of origin of your products. The regulations have always been in place, and they always require a proper country of origin. However, as we move through all these regulatory changes, the country of origin has become even more important. I've already spoken about the Section 232 tariffs and how not only the country of origin can impact your shipment, but now you must know the country of melt and pour for the steel and cast and smelt for your aluminum derivatives. We understand the rules of origin are very complex. So the closer you work with your shippers, your vendors, your manufacturers, the may be able to help you through those confusing requirements. We also have seen countries move to a country-specific tariff rate, so the country of origin should remain a priority to assure you are paying the proper amount of duty. Please remember, country of origin is not where the product is coming from, but it is where it's made. All right, my next slide is dedicated to changes with de minimis, something that we've all, I'm assuming, have seen at this point and understand and has gone away. I feel safe to say everyone that imports has been impacted. As I mentioned earlier, this is one of the most significant changes to the importing community we have ever seen. On the right side of the slide, you will see some background info on the reasons U.S. Customs has made changes to the de minimis rules. As indicated on this slide, we've seen an increase from 139 million de minimis shipments in 2015 to over 1.3 billion shipments in 2024. This increase is due to the explosion of e-commerce business and has forced the government to reevaluate the use of duty-free exclusions under the de minimis. On May 2nd, all products of China and Hong Kong were excluded from entering the U.S. under the duty-free exclusion. This made all shipments that contain any products of China and Hong Kong dutiable, which may now also include some of the trade remedies I just spoke about. This gave us a glimpse of what the total suspension of de minimis would look like. CBP also began enforcing on August 12th the rule of $800 per day per person. This was temporary, as the August 29th brought the full suspension of all de minimis shipments. This means, again, all shipments entering the United States, no matter the value, will require a customs entry to be filed with all applicable duties and taxes. This also coincides with FDA and their changes that we will talk about later. I'm sure most of you on this call are aware this has a major impact to the way that we import volume into the United States. On our next slide, we have an illustration of how the IEEPA reciprocal tariffs are being applied now. And since we are more towards a country-specific tariff rate, I wanted to cover some of the different reciprocal tariffs. As you will see, both Canada and Mexico benefit greatly from having their products qualified for USMCA trade agreements. Next, you will see the EU countries are also benefiting from a US trade agreement for reciprocal tariffs and the Section 232 auto tariffs. South Korea and Japan are also now have a trade agreement, and the rest of the countries listed are still working on trade agreements and have their country-specific tariff rates that have been in place since August 7th. A full list of all countries is listed on the executive order that I have posted at the bottom of this slide. All right, so the next slide. So to expand on the info we just touched on, this slide covers specific trade deals and additional IEEPA tariffs. I have four of the most notable ones listed here. The first is the EU European Trade Agreement. For U.S. imports, the IEEPA reciprocal tariffs are calculated using the most favored nation, or also known as the general column duty rate. If that MFN rate for your tariff number is less than 15%, then IEEPA reciprocal tariffs will total 15%. If the MFN rate is 15% or higher, then the MFN rate will be the final duty rate. So if you have a shipment that has a product that has a tariff number that carries a 20% rate, then there will be no reciprocal tariffs, and it will be utilized at the 20% rate for the general rate of column for that product. The Japanese agreement that has recently been agreed upon is calculated the same way. It appears that this preferred trade agreement calculation may be something we see more in the future, so we'll keep an eye on that. The next one is the Brazil IEPA tariffs. This is not a trade deal, but is an additional tariff placed on the current IEPA reciprocals for Brazil. This was put in place due to violations the U.S. identified where the Brazilian government had violated human rights along with hindering free speech that could impact the U.S. economy. The additional tariff is now 40%, which is on top of the baseline 10% reciprocal for a total of 50% for Brazilian products coming into the United States. The last one I have listed is also an additional tariff and is for products of India. The additional 25% has been placed on top of the reciprocal tariffs of 25% for a total of 50%. So the original 25% reciprocal two tariffs has been in place since August 7th at 25%, and now Customs has put another 25% on top of those India products. The additional tariff was placed on products in India due to India's direct or indirect importation of oil and oil from the Russian Federation. At this time, there's no end date for this. My last topic and last few slides will be dedicated to changes of the U.S. Food and Drug Administration. On July 9th, the FDA announced they will no longer allow low-value shipments that contain FDA-regulated items to be exempted from the FDA regulations. Prior to July 9th, the FDA allowed certain low-value shipments, generally under $800, to enter the U.S. without FDA approval. This previous rule helped streamline the clearance process for these types of shipments. I will say this is something that surprised all of us, as the FDA had provided no indication of these changes, and in the communication it stated that this was effective immediately. The FDA has made it clear that these changes are being implemented to protect the U.S. food supply and the U.S. population from products that are not approved for use in the U.S. The top 5 products we have seen being impacted the most are food items, cosmetics, dinnerware, radiation, and many electronics, which I will briefly discuss in the next few slides. So as we move through these products, you will see the FDA focuses on the actual manufacturer of these products and not just the shipper. First, we review food items. We see a large number of shipments that contain food items, and the current regulations state food items are still required to submit to the FDA no matter what the value. These food items typically fall within the U.S. Tariff chapters of 7 through 23 and mostly chapter 25. With these new requirements, it's very important your commercial invoice includes the normal data along with the manufacturer's name and address. If UPS has this info, we're able to submit these directly to FDA for release, and in most cases without any delay. Without this info, UPS may have to contact the importer or shipper for additional info, which could delay your shipment. The next product is cosmetics. These products will normally fall in Chapter 33 of the tariff book, along with headings 3401 and 9616. Cosmetics will need a full name and address of the manufacturer to be correctly submitted, just like those food products. So again, the name and address of your manufacturer is key and needs to be included on your commercial invoice. In the next slide, as we move forward, dinnerware is the next product we must transmit to FDA no matter the value. As you will see from the slides, there's a wide range of tariff numbers these dinnerware products fall under. The requirements are also similar to cosmetics and food. From there, we move to radiation emitting devices. These products can also fall under several HTS headings that I've listed on the slide. Outside of the normal requirements, like the name and address of the manufacturer, there can be additional FDA data and forms that are required. UPS will work directly with our customers to obtain these additional forms prior to or at the time of entry with the import. The last products we see a great deal of are biological samples. These products will normally be classified under Chapter 30 of the tariff book. For these items, in addition to the manufacturer's name and info, we also need to indicate the intended use. For example, the intended use could be something like for non-human testing only, or for investigational new drug purposes only. If the sample is going to be used for pharmaceutical, medical device, or vaccine studies, that will need to be indicated on the invoice also. We've added a dedicated reference sheet at the end of this presentation, which will provide you with all the information you will need to understand this FDA requirement more. So as you can see, there's been a great deal of change over the last several months, not just with U.S. Customs, but with other government agencies. I'm sure there's many more to come, but I can assure you UPS is doing everything we can do to assure we are providing you the best service possible and to avoid any delays and assure you're being charged the correct duties. With that, I'll turn over to Catherine to discuss some of the things still to come.
Thank you, Mark. Again, my name is Catherine, and I am in the UPS office here in DC. I'm going to talk about two things that are still ahead for us on the tariff landscape. And first, as we're showing here on the map in this slide, there are deals with countries that are, quote, final and provide some medium-term predictability. And then there are still deals waiting for finalization. And Mark spoke about these when he went through the IEEPA tariff rates. Specifically, he mentioned the EU, the UK, and Japan as having final agreements. Those are where the two governments have shared a joint statement published, which provides clarity on the tariff rate, the treatment for future tariffs on sectoral goods, and what the terms are. We wanted to show here that there are still many countries waiting for that level of agreement. Importantly, big markets like India, Brazil, and China, even though we have tariff rates, we still not have final agreements. The negotiations are ongoing, and the point of this illustration is to acknowledge that there still could be change and additional guidance in these trade lanes. In the context of the USMCA, in this illustration, it has a unique position as having both an agreement that is recognized. The USMCA is the only US FTA currently recognized by the US, but we've circled it also because the deal is under review. On Tuesday of this week, the government kicked off the official process to mark the formal review of the USMCA, and these talks will be ongoing through 2026. Lastly, on this slide, we've listed the Section 232, the, quote, national security tariffs that are applied to specific goods. Mark was talking copper, steel, and aluminum earlier. There is a list of additional investigations into products that have not yet been announced, but are being planned by the government for tariffs. These are goods which are generally outlined in Annex 2 of the Reciprocal Tariff Agreement. If you are an importer of pharmaceutical products, of semiconductors, of critical minerals, or other things listed here to the right, Annex 2 was updated on September 5, is on the White House website, and is a reference for what may be ahead in terms of new tariff rates for these goods. Moving on to the second issue still ahead, tariff litigation. The US Court of Appeals upheld the Federal Circuit Court ruling on tariffs on August 29, essentially agreeing that the use of IEEPA tariffs by the government is illegal. That was then quickly appealed to the Supreme Court, and fortunately, the Supreme Court has agreed to hear this case now on an expedited timeline. We expect oral arguments to begin in November and a decision on the IEEPA case by the end of the year. There are several possible scenarios, and while it's impossible to predict what the court will decide, and trust me, I ask many folks in DC to provide a prediction, and they don't. For planning scenarios, it's important to think of two things. In particular, if the IEEPA rule is struck down. First, that is that refunds will not become available until the government has finalized the process. Though we have guidelines at the moment for what a typical refund would look like in a tariff refund, the scenario for the scope and the scale of this refund is going to require additional guidance, and that may take some time for the government to prepare. We should also expect that if the IEEPA tariffs are struck down, that the government will work to replace those tariffs using other executive tools, meaning that a tariff-free environment with all the IEEPA removed would only be temporary as the government put in place similar levels. UPS is watching that guidance closely. As soon as there are changes, we will make those available on updates on our website. And with that, I'd like to turn to my colleague Jessica Rosen from our Trade Advisory Services.
Thank you, Catherine. So we'll continue the discussion throughout our webinar series on strategic responses that will help your business stay ahead in a volatile trade environment. So as you're building systems that anticipate and adapt to change, the analogy I like to use is a chessboard mindset, right? Thinking ahead a couple of different moves so that way you know where you need to be in response. So let's talk a little bit about the forces shaping supply chains. We have seen that ocean container rates are falling. That has happened a couple of times. It's dipped, it's gone up, it's dipped, it's gone up, and it's on its way back up. Overall, it's led to feeder vessel shortages in Asia, causes delays, and there's a focus right now to continue the upward cost trend, perhaps through more blank sailings ahead of Golden Week. And then there's the labor constraints. So labor constraints are continuing to slow down the container handling. The clearance process is a little slower, and this ties directly into overall freight costs. We also know that the ground environment elevated in general, right? So when you take a look at the courier and the operational costs associated to fuel increases. So we have a lot of increased fuel surcharges. There's the regulatory impacts that we've spent so much time on earlier, and the adjustments to de minimis, all bringing to the table additional efforts in the processing environment. The other thing to consider is the capacity remaining tight in specific lanes. So when you talk about medical items, the focus of increased scrutiny, I know there's been some changes from the EU to adapt to ISO standards. There are still regional specifics that need to be adhered to, but this change is going to bring more uniformity. In the meantime, there's still a little bit of a lag as the trade community adjusts and adapts to that. So as you can see, each section kind of is built upon another section, and they all are interrelated. And then when you talk about automation, improving the quality and reducing lead times in, a production environment, there needs to be governance in association to the adoption of any type of AI. There's legal issues, data breach issues, other pieces to contend with. So as the trade community as a whole leans more into EI or AI, then that means there needs to be, again, more time and governance put in place. And finally, in regards to the ethical sourcing aspect of it, so there is an increasing demand for suppliers to provide higher quality products, right? But for lower costs, but then also comply with ethical sourcing. And forced labor is not going away. It's continuing to be a focus of CBP and will continue to be one in the future. So we can move on and talk about, how do you spot mistakes early? Common compliance pitfalls include the incorrect classification and missing documentation. Perhaps it's a bill of material or mill test certificates that we just talked about in regards to the need to report the smelt, cast, melt, pour origins. And when you fail to provide this, it can lead to the incorrect tariff applications. One of the things that we hear repeatedly, and we'll probably keep touching on, is if you use UN as a country code, it could lead to the higher tariffs that were discussed earlier, specifically for aluminum, up to 200%. Misuse of de minimis exceptions, right? So consider with the new de minimis changes how and where you may be able to consolidate some of your shipments, altering your consumer and user model to adapt to this. Being adaptable is going to be critically important for you to either gain or retain a competitive advantage. And this is even more important for small to medium businesses. So again, as you continue to adapt to new costs within there, consider new ways of doing business. We talked about some of the PGAs and the compliance with FDA import rules. We talked about the food, the cosmetics, and all of these still need especially FDA needs to have its regulation adhered to regardless of the value. So make sure you have that full documentation and review. So checking for that is a common mistake that we see. And so making sure that that's in place and that you have your FDA forms and that you have complete invoices is going to help you stay ahead and make sure that you're adapting appropriately. And then, let's make sure that we also continue to adhere to the full compliance. Let's talk a little bit about the strong governance and the oversight to boost success. So establishing your documented process is going to be critical. When you have all of your different business units running on the same rule book, it creates an environment for that flexibility and adaptability that you need. That includes procurement, logistics, compliance. Those that do not view that as a cost center, but as a necessity to have that in place are going to be much more advantageously placed than other businesses. Having consistent SOPs with your suppliers and brokers around the world is going to be key. Making sure that you assign clear ownership and accountability, and make sure that when you make changes, those changes are filtered throughout the organization. So again, maintaining that import and export documentation, and also conducting regular risk reviews. So as we're going amongst all of these changes and we're adapting as quick as we can, have your risk assessments fallen off. There's always an area to improve, and this is one that we would always say there's opportunity to do an internal risk assessment. You could also do an external risk assessment and make sure that you're on the right track. Make sure that you have all of the processes in place that you need, where if you make one change, the changes go throughout the organization. I'll give a quick example. A company could discover that a supplier had changed, right, because of the country of origin, and they had a documented compliance policy and a formal change protocol. That formal change protocol should trigger a review of classifications, et cetera. And that's going to be necessary to make sure that you maintain the compliance aspect that you need as you make changes with the business. Ongoing training. So we always say, at least recently, that the compliance are now the cool kids on the block. And with that and with that CEO level visibility, we need to make sure that everybody else is aware of what's going on. So ongoing training, making sure that you yourself educate the rest of the business and are current within the trade and tariff agreement changes. Attending webinars like this are great. We also encourage companies to take a look at our resource sheet that we will provide at the end, that will provide other areas that you can follow for proper updates. Okay, and then we'll move on to the next slide, which is going to be transforming your supply chain strategy. So here we'll list the current state. I'm not going to read through these, but take a quick look. If you're checking any of the boxes in this section, then there's opportunity for you to adapt and to improve. And so we'll go to the future state. And to transform, right? Take a look at consolidating brokers and forwarders, implementing some global automation strategies, and integrating. So your global providers, with all of these changes, they should be well trained as a forwarder to help you navigate routing options. A well-trained broker can help you avoid costly compliance errors. Your broker and your forwarder should be more than just a processor. They should also be bringing enhanced opportunities to your business, helping you to identify areas to reduce risk, and helping you to overall look for other opportunities. If you were to develop a uniform process and control internally with a single point of contact, that is very advantageous. That way, again, you have that kind of top-down umbrella opportunity for all changes to be communicated throughout the organization. So having consistency in that area is going to be important. Multi-user global visibility tools. So does your forwarder, does your broker have an opportunity for you to have a data pool that you can get all the information you need to do a proper analysis? Are you taking a look at alternatives? If then scenarios, if the tariffs change, do you have a backup plan and contingency for sourcing? And then creating a model of oversight that allows for the overall, again, I talked about the data pool, but the global knowledge, the footprint that's necessary for your forwarders and your brokers, concentrating on one country and one carrier or one service provider really is a limited scope for you, and having your opportunity to look a little bit further to those contingencies in other countries and region is going to be important. And then finally, does your service provider have additional expertise to support you in regards to any type of assistance you may need with the automation, the integration of automation for the data, and then also from an advising standpoint? And then we have tools, right? So UPS has a lot of tools and opportunities. We are a full global customs broker. Within the Trade Advisory Services Group, we have opportunities to provide you guidance with global compliance. And then I'm going to pick on a couple of these to give a few examples. We've got the foreign trade zones and the duty drawback. Could spend a whole hour talking about each of those, but those are great opportunities to mitigate potential tariff impacts, where foreign trade zones are an opportunity to bring goods into the United States, not admit them through a formal CBP process. And if you're sending those back out of the country, you don't have to pay duties and taxes. It also allows you leverage to do pick and pack operations, manufacturing, manage scrap, destruction, etc. And duty drawback is the opportunity to reclaim upon exporting the goods that you've imported into the United States, some of those duties that you've paid up to 98%, and there's typically a commission fee on that. I really want to make sure that everybody hears about Global Checkout. Global Checkout is a fairly new offering that UPS has done in response to some of the anticipated needs of our clients. It's a premium solution. It allows for seamless international shipping. It leverages technology that you can have an integration with your online shopping cart, and it gives you a guaranteed landed cost. That includes the duties, the taxes, and government fees. This is really key right now, right? As we're all trying to adapt to what are the charges going to be. This helps to ensure there are no surprise charges that are due upon delivery. It helps for a great customer experience for your customers and really can help from a global transaction standpoint, again, to boost and bolster your repeat customers. And the last thing I'll mention is our healthcare solutions. UPS has leaned in very heavily in regards to healthcare. We have great cold chain logistics, temperature sensitive management that can also help our healthcare companies stay compliant and competitive. So I hope that these slides help to outline how your business can navigate regulatory changes. And with that, we can move into the available resources. I had mentioned a couple of these before. They were mentioned from some of my colleagues as well. So there's numerous different emails that you can reach out to if you want to have an opportunity for a proposal. There's also links here for just market updates, as well as the White House fact sheet, the CBP FAQs, really great resources of information if you're not sure where to go to gain more details. With this, I will turn it back over to Anne.
Thank you, Jessica. A lot of great information. I'd like to take a few minutes to thank our speakers for sharing really important insights from their respective areas of expertise. I think it was super helpful, especially at this time of the year with everything going on. So again, thank you all for being with us. And thank you everyone for being so active in submitting questions in the Q&A. As we continue to answer those, I have a few commonly asked questions that we're going to take live here. And Catherine, the first one is for you. It is, can I begin planning for refunds if IEPA is struck down? And how quickly can I apply for a refund?
Thank you, Anne. That's a great question. However, I would suggest that we do not recommend planning at this stage for a refund, just given the lack of predictability in the decision making around this issue. So it would not be worth making a significant business decision based on predicting a refund. For preparedness sake, you could identify all potentially impacted entries in your ACE report or by other means so that you could have some level of readiness should that be the outcome. The guidance that we're expecting will be an administrative process that will be made available through CBP. But unfortunately, we are in a wait and see moment in this space. Thanks, Anne.
Thank you. Next question is for Mark. The question is, what are the additional fees I'm being charged on my previous de minimis goods?
So that'll come down to what the product is and if there are any additional tariffs like the 232s that I spoke of, whether it's aluminum, copper, steel, even autos. Now that these shipments that were previously done as de minimis, we have to make entry on them. We have to apply all those tariffs, no matter what the value is. So generally, it'll come down to what the product is and the tariff number that's used on it. Now, from a brokerage perspective, obviously, we have to make entry on these and our normal standard brokerage fees apply. We haven't added any additional fees because of these changes. We just are now seeing all this volume that needs to have an entry on it now. We have to process it and the standard fees now apply. So like I said before, we didn't add any additional fees from a brokerage perspective to this. But as you can see through all the complexities, we're making sure we're being compliant, we're getting your shipment cleared as fast as possible. So that's the reason why you're seeing these brokerage fees on these entries also.
Okay, gotcha. Thank you. Jessica, I have one for you. What are the risks of using UN as a country code for aluminum origin? And or what should I do if I change suppliers or if they change their manufacturing process or location?
Okay, so let's break that into two. The UN is necessary. If you just put UN, then it's going to potentially trigger higher tariffs. It could be up to 200%. If the full value of the product that Mark had discussed earlier, it could lead to compliance violations as well as cause unnecessary delays. So always making sure that you can confirm the actual smelt, pour, cast, melt, origin, and using that correct country code is going to be important for misclassification. Before I just address the portion in regards to supplier changes, I'll ask Mark if there's anything additional that you'd like to add in regards to the question on the specifics for the UN. Okay. But then let's talk about supplier changes. So if you're going to have a supplier change, or if you know that your supplier is changing where they're sourcing from, that should immediately trigger a review of classification codes. It should immediately trigger a review of the documentation that's necessary. Remember, you're expected, first of all, you're responsible as the importer of record, and you're expected to know your supply chain and where things are coming from. So you need to have the documentation. You have to make sure it's appropriate for the right customs declaration. And having a documented policy and formal process change protocol is going to ensure that all of those related processes are updated. This way you can avoid any delays, avoid any penalties, or any misrepresentation.
Awesome. Thank you, Jessica. Let's see. Catherine, I have one for you. I understand that USMCA is up for review in 2026. What does that mean? Could the review result in the cancellation of the USMCA, and what changes from the review are allowed?
Thank you, Anne. Yes, I perhaps should have been more detailed when I was presenting that, so as not to be too alarmist. The review to the questioner is right. This is a built-in mechanism. The USMCA is reviewed every 6 years, and so this is just fulfilling that process. There are a number of outcomes that could happen during the review, and a cancellation is the least likely. In fact, it's almost hard for the three parties to fully cancel the agreement before it's due to expire in 2036. A party could give 6 months notice and withdraw. So one of the three countries could withdraw, but it must be said that that is not what is expected at all. However, while we do expect all three countries to remain committed to the process to renew the agreement and extend it until 2042, we know that there is ambition for some changes in the agreement. So UPS is fortunate to be a cleared advisor to the US government. We look specifically at giving advice on issues like rule of origin and customs procedures. And we have been called into a process knowing that, as the government has stated, that they would like some updates to the agreement. So rather than a rubber stamp renewal, what we're expecting is a detailed review with potential changes. Again.
Thank you. Okay, Mark, I have another one for you, and it is 99030114 a legitimate HTS code? And can I use it on a USMCA declaration?
Yes, definitely. That is a valid tariff number. And that came in with the IEEPA 1 tariffs back in February. That tariff number is used to exclude the IEEPA tariffs of right now it would be 35%. So if you have a product that qualifies for USMCA, when that comes in and we have that NAP or that USMCA certificate on file, we will use and utilize that 9903 number to exclude the tariffs to make it basically duty free. So it definitely is a valid tariff number. And I will say all these different trade remedies, whether it's Section 232 or the IEPAs, every single country now has its own tariff number for different reciprocal tariffs or other types of tariffs. So you'll see a lot of the 9903 tariffs out there, and you'll see those on your entries if you look at that. So, but that is a very good example of how we would utilize that to avoid duties and taxes for USMCA.
Perfect, thank you.
Yep.
I think we have time for one more. Mark, this one's for you as well. If
Mhm.
duty is 6.1%, are we
Okay.
correct in assuming the reciprocal tariff would be 8.9% for a total of 15% under the US-Japan agreement?
Yes, that's exactly right. And the original Japan agreement come out and said it was a flat 15%. Now that was updated recently to that exact formula. So if you have that 6.1% general rate of duty for that product, the rest, moving all the way up to 15%, would be the reciprocal side. Now, on the opposite side, if the general rate is 20%, then really the reciprocal rate will be reported as 0, and you'll stay with the 20% since that tariff number in that product carries a 20% rate. Hopefully that helps.
Okay, perfect. All right, well, thank you all for joining us today and for all your engagement throughout the session. As we've seen, trade regulations are evolving rapidly, and staying ahead of these changes is key to maintaining compliance and protecting your business. We encourage you to revisit today's insights, share them with your teams, and continue the conversation. So that concludes our webinar today. If you have any further questions, please don't hesitate to get in touch with us through the contact information on the slide or on the post-event survey that will pop up once this ends. We appreciate your trust in UPS, and we hope you have a wonderful rest of your day. Thank you.